can't be leaving you alone with some guy overnight, whether you're in love with them or not, and they've been to prison before.
I'm sorry for everything.
But why would you do it? 2025 CR 0018232, State versus Juan Cruz. Can I have parties announced?
Ashley Jones for the state.
Christine Brown on behalf of Juan Cruz.
And are you Mr. Cruz?
Yes, ma'am.
Counsel, you received all discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery and there are no applications, correct?
There are none.
Mr. Cruz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We waive the reading of the indictment. We did want to note that the state is moving to amend it, and we waive that 10 days notice attached to that amendment.
All right.
Yes, Your Honor. The state is moving to amend the indictment to reflect the correct spelling of the pseudonym name as well as the word pseudonym.
Mhm.
So we are just changing that. And then additionally, we are proceeding only on count 3.
And defense, you have no objections to those changes or the waivers?
I have no objections to those changes, and we waive the 10-day requirement.
And Your Honor, the word pseudonym is actually misspelled.
Okay. All right. Mr. Cruz, did you review the court admonishments with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right. In count 3, you're charged with aggravated assault of it's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow that plea. If for any reason the court does not follow that plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? All right, we can go off the record for a moment. Do you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court, just one second, I'm sorry. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Oh, no, no.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea, you can be deported, denied naturalization, or the right to re-entry into the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 3. They're asking that your punishment be assessed at 25 years in the prison. There's a $1,500 fine. There are no applications. There's to be Chapter 62 compliance.
Right away, this plea deal tells us the stakes are enormous. A first-degree felony carrying up to life in prison has now been negotiated down to a fixed recommendation of 25 years, but here's the question. What evidence convinced both sides that a trial was too risky? Keep watching.
And there's to be no contact with the complainants. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Yes.
No pretrial motions of that sort. No.
Then to count 3, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. The state would enter into evidence States Exhibit 1 and all of that.
No objection.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
All right. Anything you wish to say on behalf of your client?
And just like that, the court officially finds Cruz guilty, but surprisingly, the most revealing part of this hearing is still ahead. Sentencing hearings often expose details that never make it into the formal plea documents, and Judge Boyd isn't the type to leave important questions unanswered.
Yes.
Yes.
And so the defendant, my client, does understand the ramifications of the charges involved. It was very difficult in terms of assessing what was at stake here. We have entered a plea to avoid the inherent risks of trial. The client, we are just asking that the state follow this, that the court honors this agreement. This has been the result of numerous meetings with the state, going over the evidence, and the state has conferred with the mother of the child. And this is a conclusion that everyone is in agreement with.
That is correct. Yes, sir. Yeah.
Anything you want to say?
Just want to say that I'm sorry for everything.
But why would you do it?
Like in a way that
I'm sorry, what?
I would say I'm sorry for
Sorry for what?
for the pain that I for her and everybody, the not being a better husband to her, to
Well, I mean, according to the stipulations, you're the boyfriend. You're not a husband.
or boyfriend, yeah.
So how long did you know them before you moved into the home?
Like about 2 months.
So you knew the mother for 2 months before you were moved into the home?
Somewhere around about 2 months.
Right. And how long after you moved in the home that you were allowed to spend overnights with just you and the complainant?
How long?
Yes. So you move into the home within 2 months.
Because I would work at night. I'll come home. I work night shifts and 11 o'clock, 12 o'clock.
Well, they're saying this happened overnight.
Yeah.
If I may interject, just regarding the facts of the case, since we're discussing this, my client had been on parole at the time these allegations were made. There was a parole hearing at which the mother of the testified, and during that hearing, she had stated that.
Oh, okay. But I want to hear this.
She had.
I understand it's hearsay, but I want to hear. Yes.
And so this is what I had pointed out to the state when we were coming to this conclusion, this proposed amount. The mother was relying on him routinely throughout the course of their relationship to watch that as she worked nights. She works as a housekeeper at the Metropolitan Methodist, the hospital on McCullough. And so that was an aspect here where she had asked him to watch the kids.
So when did that start? When did it start that you were allowed to watch as somebody's boyfriend that has only been moved into the house for 2 months?
For me to watch her, that was my girlfriend. We've been living, we got the house together. I'm the one that got the house. And
how did you meet her?
Through Facebook.
All right. So you meet through Facebook. And when you meet through Facebook, does she already have children?
She already had children. She told me about her life story.
Well, no. I just want you to listen to my questions and answer my questions. So you meet her through Facebook.
Yes, ma'am.
She tells you she has children.
She didn't tell me at the beginning,
Okay.
not till afterward that we started talking.
All right. And so when you met her through Facebook,
Yeah.
did you already have prison history, or did the prison come?
This is where the hearing takes a dramatic turn. Judge Boyd isn't just focused on the defendant's actions. She's questioning the decisions that allowed access to the child in the first place. It's a reminder that in cases involving minors, courts frequently examine the broader circumstances surrounding the offense, not just the offense itself.
After you met her?
No, I already have
And so what did you go to prison for?
for burglary.
All right. So
Never had no.
did you tell her you'd been to prison for burglary?
Yeah, because of ex.
So you tell her, you meet her on Facebook.
Mm-hmm.
She has, and you tell her that you've been to prison for burglary.
Yeah, so
And then she says, great, you guys move in together. Okay,
Your Honor, maybe
Yes.
I can ask the defendant some questions.
sure. I mean, he gave it the right to remain silent.
Mr. Cruz, isn't it true that you knew the child's mother for 9.5 months before you guys moved in together? Does that sound more correct?
Yeah, I know. Pretty much something like yeah.
And isn't it true that she had her father living in that home as well?
Yes.
And isn't it also true that you guys met through friends and not on Facebook? Would that be more correct?
Then like Facebook, because she knew my sister and all that.
So you guys knew
That's
each other
yeah.
from people, not something that you met online.
Yeah, so
No further questions.
All right, anything else?
If I can briefly ask him, and was it your understanding that there were past allegations made against another family member in the house by the same child regarding sex abuse?
Section 12 is
Overruled.
yeah, her dad, her ex-boyfriend.
All right.
Or her son.
The son, would that be the
Yeah,
that
Jay.
brother?
They had brothers. She had said that her son had did something to her. Her own son.
And then what was the outcome of that allegation?
Nothing about it. I always told her you so she didn't want to go.
And what is your understanding of her relationship with a man in a case where she was a complaining witness for continuous violence against the family?
And that was her ex, her baby daddy. She told me that they had got an argument and she hit him in the car and she ran over, he hit a bump and he was trying to put the car in gear and
What is your understanding of their relationship now?
they're gonna get back together. She could put him in prison for 4 years for domestic violence.
How do
He
you know
gets
that he
out.
was going to, how do you know that
She
they were
told
going to
me.
get back together?
She was talking to him. He would call her on three-way from people from prison. I was for a lot of arguing and I tell her, why you talking to me? Like, just leave. I'll leave the house. She was always arguing with me.
Okay.
I just leave. I didn't want to get in trouble.
No further questions.
Okay, thank you.
Redirect, or is that process?
Sure.
How, you don't know for sure that she's with the person who abused her, isn't that true?
Why? I mean, she was talking to him through the phone. Like when I,
Surprised you to know that she has a restraining order against him?
yeah, but she would still get letters for her friends. He would send letters to her friends' house.
Objection to inaccurate statement, restraining order, would that be a protective order? I mean, that's.
All
to me,
right, if you could clarify your question.
Yeah, a protective order, Your Honor. Are you aware that there's a court order prohibiting him from talking to her?
Yeah, but and that's why I would tell her why she talking to him, and he was still calling through.
No further questions.
And I didn't, that was one of the main ideas.
All right. Is there anything else?
Nothing further.
All right. As previously stated, the court is going to find you guilty of count 3. The court will sentence you to 25 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrently. Chapter 62 registration. There's to be no contact with complainants. There's to be no residing with minors. And there's to be no unsupervised contact with minors. Anything else with regards to sentencing?
Okay, Your Honor.
Nothing further.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. The fact that some people are not paying attention to their children doesn't excuse your behavior. I have no idea why people will hang their star to somebody who's been to prison, which I believe in rehabilitation. But when you have children, you can't believe in rehabilitation because you have to protect your children. You can't be leaving your children alone with some guy overnight, whether you're in love with them or not, and they've been to prison before.
Yeah.
And so I'm putting no residing with children because ultimately when you're released from prison, somebody's going to see that you're registered. You may or may not tell them, I didn't do it. They're going to believe it. They're going to allow you around their children because for some people, you're a great catch and they don't pay attention to their children. They don't recognize that, hey, this child is 100% dependent on me for their protection. I can't leave an adult male in the home because sometimes this is what happens, but that doesn't excuse your behavior at all. Do you understand?
Yes, Your Honor.
And you are not allowed to reside in any household that has children in there when you're released from prison. So if you meet somebody on Facebook, if you reconnect with somebody and they have a child residing with them, you can't live there. You can't spend the night. You can't be over there. Do you understand?
Yes, Your Honor.
All right, thank you. Court is calling 2024 CR 1657, State of Texas versus Christopher Acosta. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Megan Enriquez, present for John Hewens for Christopher Acosta.
And I'm assuming he's only pleading to one case?
That's correct.
Are you Christopher Acosta? Counsel, you received all the discovery. Did you review it with your client?
We did, Your Honor, and we have reviewed it.
All right, court will find that the state is in compliance with discovery. Mr. Acosta, do you have any objection to this attorney standing in for Mr. Kuntz?
No, ma'am.
Going to show you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it? Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? You're proceeding on one of the enhancements, is that correct?
Proceeding on the second enhancement.
All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? Normally, that's a third-degree felony. However, the enhancement allegation is proven to be true. Then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Acosta, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, You would agree that you've been previously convicted of one or more felonies for enhancement. Punishments to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. State opposes your application. They're taking in consideration 2023 CR 4342, and there's to be restitution to SAPD for blood and drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And to the enhancement in paragraph 2 of the indictment, how do you plead? True or not true?
True.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
All right, you can continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. All right. So, state and defense. The court has in the stips, the judgments from paragraph 1, not from paragraph 2.
It should be behind that, Judge.
Yeah. The other one is 4-8 unless in the indictment, it's incorrect. So I don't have 2014 3050.
I was just.
Yes.
Okay, they have a. Let me check on that. That's
30.
0.
But there is the one that ends in W in there.
That's probably what we'll do, Judge.
All right. So then the state, are you proceeding on paragraph 1 of the enhancement instead of paragraph 2?
Yes, Your Honor.
All right. And defense, do you have any objection to that?
No, as long as
Correct.
the other one is being waived and
Yes. So how do you plead to paragraph 1 of the enhancement, true or not true?
True.
All right. Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Is it 6 weeks for? All right. So I'm going to get a setting for you. We'll come back in 6 to 8 weeks. And at that time, I'll make a decision on your application based upon the PSI report, the top evaluation, and any other evidence that's submitted.
Your Honor, I don't know what the timing is, but he has a doctor's appointment on April 10th. Can it be after that date of April 10th?
Sure. All right, we can put it for April 11th. Yes.
Thank you, Your Honor.
Before you leave, you'll need to sign the reset form and speak with probation.
Yes, ma'am.
Thank you, Judge.
All right. Thank